This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is...
I declare the meeting open to the public. Can I remind members that the committee meeting will be recorded and broadcast throughout Parliament buildings as well as online. We have got 5 members attending in total, with 4 in person and 1 member attending by video conferencing. So we've got Emma Sheeran, Mike Nesbitt, Paula Bradshaw and Michelle McIlveen in the room, and Mark Durkin via screen, and John O'Dowd, who's attending in his capacity as Caroline Cullen's deputy, will be joining us later on. We have one apology from Christopher Stalford, and if the committee are happy, we'd send him his best wishes. I believe he's in hospital, so I'm sure everyone's happy to send him a full and speedy recovery. So if we can move on to the second item on our agenda, we've got a briefing on the Canadian Charter of Rights and Freedoms by Kent Roach. So you'll recall that before the summer recess we had heard about the experiences of Bill of Rights internationally. Today we'll be receiving a briefing from Professor Kent Roach from the University of Toronto, a leading professor of constitutional and criminal law, about the Canadian Charter of Rights and Freedoms. The clerk's memo on this can be found at page 5 in your meeting pack. Also included is the Canadian Charter of Rights and Freedoms, which I believe Professor Roach will be referencing. So I'd like to welcome to the meeting Kent Roach, who is joining us from Canada. Kent, can you begin your briefing?
Okay. Well, thank you very much for asking me to speak to you, and I wish you all the very best in your deliberations. So, as you see, the Canadian Charter of Rights and Freedoms was added to the Canadian Constitution in 1982. In my view, it has been a success, which is not to say that improvement cannot be made upon it. But I think it is important to realize that it was our second try at a Bill of Rights. We had a statutory Bill of Rights in 1960, which in many ways the courts and civil society were not ready to use it as an instrument. Of particular interest, I would think, to you in thinking about a Northern Irish Bill of Rights is the fact that the Canadian Charter goes beyond the conventional rights that you would find in the European Convention or the American Bill of Rights, and has rights that are really central to the history and multicultural nature of Canada. So, for example, there are linguistic rights, both rights with respect to the use of French and English in federal institutions and in the province of New Brunswick. And there are minority language school rights, so positive rights, a variety of socio and economic and cultural rights provided in the Charter. These have, I think, largely been a success, although there has had to be some litigation. And one of the things that I will touch on later is the use of effective remedies in litigation. Other things that are particular to the Canadian nature is I would direct your attention to sections 27, 28, and 29 of the Canadian Charter, where in recognition of the multicultural nature of Canada, Section 27 talks about rights being interpreted in a manner consistent. Section 28 was added at the last minute because of concerns by women's groups. So it says, notwithstanding anything in this charter, the rights and freedoms are guaranteed equally to male and female people. And Section 29 is a provision that recognizes that in our first constitutional document in 1867, there were denominational school rights with respect to the Catholic minority in Quebec, the Catholic minority in Ontario, and the Protestant minority in Quebec. Now, those rights or those provisions, 27 to 29, have really not featured that much in our over 30 years of charter jurisprudence. Now, as you may know, I'm not in the camp of those like Jeremy Waldron or Richard Elkins, who sees Bill of Rights as undemocratic. Like many Canadian scholars, the late Peter Hogg, I have written about the Charter as promoting a democratic dialogue between the courts and the legislature. And for me, I think it's important to underline that the engine of dialogue, that is the idea that a Bill of Rights does not need to produce judicial supremacy, is not the Notwithstanding Clause in Section 33 of the Charter, which has never been used by the federal government and is rarely used by the provinces, but rather is our general limitations clause in Section 1. And so Section 1 provides that all of the rights in the Charter, and of course the Notwithstanding Clause only applies to some of the rights in the Charter, but Section 1 provides all the rights in the Charter are subject to reasonable limits prescribed by law that can be demonstrably justified in a free and democratic society. And it's there that the back and forth really goes on. So on issues like tobacco advertising, criminal law rights, there's been a lot of back and forth with the courts saying, okay, well, this version is not justified, and Parliament very quickly often coming back with a new version. And I see that as a healthy interchange. Just to round out, because I want to leave you time for questions, I want to address 4 things that I would change or I would improve about the Charter, because obviously no document is perfect, and it was drafted a long time, or I mean, I was alive. I was in university, but that's just aging myself. So anyway, the first thing is our pre-enactment scrutiny is deficient, and I think that there are a lot of models that you can look at. The Federal Department of Justice has, in recent years, tried to improve this by going beyond its statutory duty, which it's never exercised, to report that a public bill is inconsistent with the Charter, to having more of a free-flowing Charter statement. But even with this improvement, I don't think we in Canadian legislatures look at the Charter implications of laws. And I think that also explains why there are fairly high strike down rates still. So I think that the legislative process the Charter should play a role there, although I hasten to add that my own personal belief is that it needs to be focused on the issue of limitations rather than Jeremy Waldron's idea that, any reasonable interpretation of a right prevails. My problem with Professor Waldron's approach is that it will generally be the majority's reasonable interpretations in a legislature. And I do believe that courts and human rights tribunals both have an important anti-majoritarian role. So I wouldn't look to Canada on pre-enactment scrutiny. Second is, I think the remedial performance of Canadian courts has not been great. We have a general remedies clause that says a court of competent jurisdiction can award any appropriate and just remedy. But our courts have often relied upon general declarations which are sometimes difficult for governments and civil society to know exactly what they mean. We have had one case where the Supreme Court, in a 5-4 decision, said there could be continuing jurisdiction. That is, a court could ask government to report back with respect to the construction of minority language school facilities. But that was a very controversial case. And since that 2002 case, our courts have been fairly deferential on remedies. And this has created, I think, some legitimate dissatisfaction because obviously a right that does not have an effective remedy or a process in order to resolve disputes about the remedy is not going to be a meaningful right. And I would think one of the things that I've tried to, without success, champion in Canada is the idea of what I call a declaration plus. And a declaration plus is when a court declares the existence of rights, perhaps in a general way, but retains jurisdiction. And I guess this could also be done through a reference procedure as further disputes and complications about the meaning of those rights. There's also an idea that if there is a declaration, there's a legitimate expectation, I think, that governments consult with the right holders about exactly what that means. Because generally courts are going to operate at the 10,000 foot level. And when you get down into the trenches, the questions become much more difficult. The third is if you did have a yes, and the last thing I would say is we've used suspended declarations of invalidity a lot, even though they're not specifically provided for in the Charter, and we don't have something like the South African Constitution that provides it. But they have, I think, been fairly useful. Although I do think that we need to think about what happens to the actual applicant if they receive a suspended declaration or even a non-binding declaration of incompatibility. And I believe that the Irish bill south of you provides for the idea that you could at least give the applicant damages. Although my own preference would be to allow the court to make that decision. The third is our Notwithstanding Clause. I agree with the Notwithstanding Clause, but I would, if I was redesigning the Charter, I would say it can only be used after and in response to a court or tribunal decision. And I say that because it allows for a dialogue and the public, which can then hold the government responsible for the use of the Notwithstanding Clause, will at least know what's at the other side. Where I think there is a danger that when you use the Notwithstanding Clause without a court decision, it's often used as kind of a populist sort of tool and combating sometimes a straw person. And then finally, and I think your next speaker will speak to this in greater detail, I think it's regrettable that socio and economic rights were not included in the Charter. We've included various cultural rights, but I think the next generation really should include some form of socio and economic rights. So those are my initial thoughts. I have a lot more I could say, and I look forward to your questions.
Thank you very much, Professor, for your presentation. I'm going to start with some questions, if you don't mind. So looking at the Charter that you have, and you've pointed out the things that you would add or change, and obviously we're in the process now in the North where we're leaving the EU, and that leaves us in a period of transition. And I'm wondering what you would say we could add to in terms of our rights in the face of Brexit?
Yes. Well, I'm not an expert on Brexit, but it does seem to me that the peace agreement, the little I know about Northern Ireland, seems to be something that is quite essential to Northern Ireland. So really all I could say is that you can use a Bill of Rights to express elements of your particular society's values and your particular society's history. And that can be done through a range of ways. It can be done through explicit rights. It can be done by saying rights will not affect a pre-existing value or institution. And it can be done through an interpretive way. I also think that you need to think about what are the legitimate objectives of limits on rights. So the European Convention and the Human Rights Act stem from a time where there are particular rights: public order, safety, reputation, the rights of others. The Canadian model is, in many ways, almost any objective goes. But I have written about how some objectives are so symbolic that they're not really amenable to proportionality analysis, which is generally a fairly instrumental form of analysis that says, look, here's an objective, public safety. Is this limit on rights really necessary in order to achieve public safety? And when legislatures have, very symbolic and vague objectives, like, preserving decency, preserving the rule of law, then the problem with that for courts and tribunals is it's difficult to subject that to proportionality analysis, asking whether it's rationally connected, whether it's the least drastic means, and whether it has an overall balance. So I do think that you might want to think about what are the lists of whatever rights you come up with, which can reflect Northern Ireland's values and aspirations, but also think about what limits on what are the range of legitimate objectives. And it may be that to preserve things that you value that could be threatened by Brexit, that should be specifically enunciated. I mean, it's always a battle, because bills of rights are supposed to be written for a long time. But I also would take from the Canadian experience that in 1982, we put down things that we thought were important to the Canadian identity, particularly with respect to cultural rights and multicultural rights. And those haven't done us wrong over the over 35 years that we've had the Charter.
Thank you. And what you're saying there, I suppose there's a couple of elements that are topical when you look at the Canadian Charter. I mean, the mobility of citizens. And so we're having a conversation at the minute, obviously, we're staying in the ECHR, but we're losing the Charter of Fundamental Rights when we leave the EU. And there are worries there about how mobility of citizens in the North are going to be maintained. Could you sort of give an opinion on how we could maintain the rights that are in the Charter, or try and plug that gap with a Bill of Rights?
Yeah. Well, I mean, I think that that's a tricky question. I mean, you're very right that we have mobility rights in the Charter. They haven't been very much litigated, but they are mobility rights within Canada. So it's about going from one province to another province. And the other thing I probably should have mentioned in my original talk is there is a commitment in the Charter to affirmative action, both in Section 15.2 with respect to equality rights, but in sections 6.3 and 6.4 with respect to mobility rights. So this was designed so that, you know, a province like Newfoundland and Labrador could favor the hiring of its own citizens. I think in your situation, the issue of mobility rights may be a little more tricky if you're talking about mobility rights to England or Scotland, Wales, or the Republic, because it would involve extraterritorial issues. And, you know, for what it's worth, the Canadian courts have really struggled with the issue of how the Charter applies beyond the borders. So I'm sorry, but that's really all the help I think I can be on that particular question.
No, thank you. And I suppose what you're saying there is flagging up this interesting point, because we live in a place where, you know, a portion of the population would identify with the south of Ireland, would identify as Irish. Then there's a portion of the population identify with mainland UK, identify as British. And so then there are mobility challenges for both within that. And, you know, it's about borders, and then borders that people don't think of as borders. So it's difficult to navigate, I suppose. But
yeah, and also, I mean, I think that the symbolics of any Bill of Rights requires you to think about issues of equality and reciprocity. And so that has certainly been the Canadian history, that even back to 1867, there's a reciprocity about how the Protestant minority is treated in Quebec and how the Catholic minority is treated in Ontario. And that remains very important. And so, you know, again, I think that, you know, there are lots of other examples outside of Canada where there's kind of directive principles, preambles, and the like. And I think that you obviously want to consider the full range of ways to express the values of Northern Ireland that you very much hope to preserve in what I appreciate is a very difficult challenges that you are currently facing.
thank you very much. I'll pass to the other members. Mike.
Chair, thank you very much. And Professor, thank you for your presentation. Of three areas I'd like to explore with you. The first is the relationship between the Legislature and the Judiciary. Could it be said that a Bill of Rights makes the Legislature less supreme, that the Judiciary then becomes the ultimate arbiter? And yet, in your case, the Notwithstanding Clause suggests that actually the Legislature still retains the ultimate control. So is that a tension, and how do you resolve that?
Well, I mean, I think that it is a creative tension. I actually don't support either legislative or judicial supremacy. I think in a democracy, we shouldn't really think just about who has the final word. But as I said, I think that this is a misconception, especially outside Canada, that it's the Notwithstanding Clause that kind of really does the work of interchange and dialogue. It really is, I think, the Limitations Clause and ideas of proportionality, which are really increasingly recognized in human rights law throughout the world. So I think most of the creative tension is the legislature does something, often for a really good reason, and what the court does in part motivated by the concerns of real people and litigants, is to say, well, what about the effects on this person? Is there any way that you can achieve this objective without doing this much harm to this person? And, I say that not because I think that courts are good or legislatures are bad or vice versa, but simply that the institutional position of a legislature means that they are probably going to neglect individuals who, for whatever reason, have not appeared before them, have not appeared before committees to voice their concerns. Courts have to listen to those individuals. And so that's why I think that you have a more democratic balance if you have both legislative and judicial voices. Even with respect to the Notwithstanding Clause, it's a mistake to think that this is, the legislature uses it and the legislature wins. Because when the Notwithstanding Clause is used, it expires in 5 years. And 5 years was chosen very deliberately because there's also a constitutional requirement, I believe in Section 4 of the Charter, that there has to be elections every 5 years. So in some ways, when the legislature uses the Notwithstanding Clause, they are committing themselves to renewing that debate. And an interesting feature is, say, for example, when Quebec used its Notwithstanding Clause to affirm legislation to protect and promote the French language, it decided that was done in 1988. By 1993, it allowed the override to lapse. And that was in part because people went to international committees under the optional protocol. They went to the UN human rights, but also matters, and tempers had cooled down in 5 years' time. So even the Notwithstanding Clause, which is not the main engine of dialogue, is not about the final word. It's actually about committing to a social process, about having a debate. And, when the Notwithstanding Clause expires in 5 years, yes, the legislature could renew it, but if the legislature does not renew it, then in cases where there's been a judicial decision, that judicial decision still kind of rises like a phoenix after it. So I think it's very much not about who has the last word, but a process that allows for best governance. And for me, I think, I have a lot of respect for legislatures. I have a lot of respect for courts, but I think that they do essentially different jobs. And I think that we're all better off when they can both do their jobs.
Thank you. Second point, do you think that a Bill of Rights is more effective in a jurisdiction which has a written constitution?
No, I don't. Charter interpretation by our courts is very different than interpretation of other parts of our written constitution. I do think, though, that a Bill of Rights is only going to be of value to the extent that litigants and tribunals, whether it's the ordinary courts or the Human Rights Tribunal, are prepared to accept it. So, that's why I mentioned the 1960 Canadian Bill of Rights. Our courts were really just not prepared to interpret human rights from 1960 until 1982. And they were criticized by academics, by civil society. And I think that when the charter was enacted in 1982, the courts saw this as an opportunity to do a better job. And they very much learned the lessons of the failed Canadian Bill of Rights. So I don't think it's so much a written constitution, but I think that unless you have a Bill of Rights that excites people, that has civil society conferences, that has academic conferences. There's a lot of work that has to be done in order to prepare for a Bill of Rights. And one of the interesting things is equality rights under the Canadian Charter did not take effect until 1985. So the rest of the Charter took effect in April of 1982, but there was a 3-year preparation for equality rights. And that was supposed to be so governments and legislatures could get their house in order. But the other thing it did is it allowed a spate of civil society and academic activism about what equality meant. Because frankly, under the Canadian Bill of Rights, the court said fairly ridiculous things like, if you discriminate against a pregnant woman, it's not because of gender, it's because of pregnancy, which was, just kind of a silly, formalistic, legalistic sort of decision. And it was partly because so many people had criticized and frankly ridiculed that judicial decision that our Supreme Court took a substantive equality approach, which interestingly enough had been pioneered not by the ordinary courts, but by the human rights tribunals. So I guess my advice for you would be that make sure whoever is going to interpret and litigate this new Bill of Rights has lots of preparation time, that they're enthusiastic, and that they're going to make the words on paper actually take life.
Again, thank you, Professor. Just finally, paragraph 5 of the Charter says there shall be a sitting of Parliament and of each legislature at least once every 12 months. Now, infamously, this legislature collapsed in 2017 and didn't meet for 3 years. So I'm wondering, how would you enforce that paragraph 5?
Yeah, well, no, that's a great question, and of course we haven't had that experience, although you never know. There may be litigation over it. We're going into a throne speech, and most of the opposition is out sick, and we haven't provided for virtual voting. I think that the courts really would have to do that, or the tribunals through their declaration power. I don't think that the courts would order the legislature back in terms of injunctive relief. But again, I think that's why you need to have remedial creativity and a space between a declaration and an injunction. So a declaration is basically the court saying, you really should do this. An injunction is you must do this, and if you don't, it could be contempt of court. And I think that we need a kind of space between there. So I would hope that the court would declare that the right exists, and perhaps be open for any possible justification about why a limit on that right is necessary.
Professor, thank you very much.
Thanks, Mike. That's you.
Okay, thank you. Thank you very much for your presentation. It's been fascinating so far. My question is, we had a few weeks ago a presentation regarding the South African experience, and I was struck by how important their preamble was in terms of sort of setting the context of their shared history and contested history, maybe the better word. But I'm just wondering, to what degree do you, I don't think there is one in yours, but to what degree do you think that should be an important part of ours? That's the first question.
Yeah, no, I mean, our preamble has not really played much of a role. It simply provides, whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law. And so there has been some litigation about the rule of law, but the courts have not really done a lot with the preamble. So, I mean, I think this really speaks to the different audiences of the preamble. courts are not always enthusiastic about preambles. They tend to see it as kind of, political surpluses. But I think that civil society and citizens do take preamble seriously. So I'm not opposed to a much more elaborate preamble, and I certainly understand why South Africa used it, and it may be appropriate in the Northern Irish context. But I think the lesson of the Charter is you should take some of the values that you articulate and some of the aspirations that you articulate in the preamble and think about ways of working them in to the actual rights or limits or non-derogation clauses within the operative provisions of the Bill of Rights.
Oh, thank you. And the second question is, at the very end of your formal presentation, you had said that they maybe should move towards, or maybe should have moved towards, inclusion of socio-economic rights. And I'm just wondering if you could elaborate on that a little bit more, please.
Sure, no, and of course, this may be relevant with respect to the previous member's discussion about the European Charter of Rights. I mean, it seems to me that in our world of growing inequality and perhaps scarcity going forward, that the political and civil rights are really not meaningful if you don't have shelter or food. And I think that we need to think about the way to incorporate them. So the South African Constitution provides one way, the Indian Constitution and the Republican Irish Constitution provides other ways. But it seems to me that the trend of history is towards judiciable socio and economic rights, although subject to reasonable limitations and perhaps progressive realization. But again, I think that a Bill of Rights has to be practical, and you have to think about how those socio and economic rights will be enforced. There was some discussion at one point of amending the Charter to provide for socio and economic rights that would be enforced not by the courts, but by a different institution. Again, without saying that one is superior to the other, I think socio and economic rights are necessary in order to make all the other rights meaningful to real people. But I also think that whatever method you choose, you have to think very, very carefully about enforcement. Because in some ways, I think the days of simple directive principles have passed. And I think that if you don't have some meaningful way of enforcing social and economic rights, it could create cynicism about all the rights.
Okay, and just to bottom that one out a bit then, a phrase or a premise that's come up quite a bit is around environmental rights, and to what degree is there a discussion going on in Canada around those and maybe taking that forward?
Yeah, again, I kind of come back to the practicalities. So one of the problems with environmental rights is it's not clear that someone would have standing to vindicate environmental rights unless they could demonstrate some personal effect. So again, I think environmental rights are obviously important. And again, I would suggest whatever way you go, you think about how you're going to enforce it, but also who you enforce it. So I also think that you need to have broad standing rules that allow civil society groups and not simply affected individuals to bring these collective claims, such as environmental rights. And I think that that's something that in some ways you cannot rely upon the courts to be creative. Some courts have been creative, but many have not. And so you really need to think through the nitty-gritty of standing and enforcement when it comes to environmental and other forms of social and economic collective rights.
Thank you very much. Thank you.
Thanks, Paula. Michelle?
Yeah, thank you, and thank you very much, Professor, for your presentation. A number of the areas that I wanted to touch on have already been referred to, but just in relation to advice in respect of remedies, which could be used by courts rather than just merely striking down legislation, what would you advise in relation to that?
Right. Well, thank you very much. It's an area that I've written on. Well, I do think that a suspension power is something that you want to think about. I think that in our era, the strike down or even the declaration of incompatibility is too blunt a remedy. And so there may be areas where the courts have something important to say, but they don't want to create a legislative vacuum. And I think that drawing on South Africa, Canada, Germany also uses it. Suspended declarations say basically this is unconstitutional or this is contrary to the Bill of Rights, but we're going to give you a year, 2 years in order to fix it. But I do think that you could be more creative than either Canadian or South African courts have been and think about a process so that, courts are not experts on the substance, but they are experts on the process. And so I think that something about, the court would say, you got 2 years to fix it, but I think that you need to consult X, Y, and Z. I think that is something that should be looked at. Also, this idea that when courts declare rights, they are functus, that their decision is over, I think is something that you want to rethink. Is that if you have a judge or a tribunal that has heard a lot of evidence in a particular area, that person has expertise, and it's been expertise that the public has paid for. And so I think you want to think about creative ways that that person could come back. So in one of our leading minority language education cases, a judge said basically the whole province of Nova Scotia had not complied with French language facilities. And he was dealing with 5 different regions of the province, which is probably about the size of Northern Ireland. So a lot of geographic complexity. And so what the judge said is, I want the government to report back by way of affidavit periodically about what's happening, and I will allow the other side, the French language parents, to comment on those affidavits. And that was upheld by a narrow majority of our Supreme Court, but seems to me to be an eminently sensible device that actually benefited the government. Because what happens if, they're trying to build a school and there's a construction strike, or there's shortages, or there's some other unanticipated problem? I think the ability of the parties in a fair and open way to come back to the tribunal for further advice is frankly an efficient and effective way to govern. But that was extremely controversial because 4 of our judges said once the judge made his ruling, he was functus. He was done, and he had no other part. So I think that you have to anticipate that courts are by nature conservative institutions, and you have to nudge them towards more creative remedies. So certainly a basket clause that allows the court to come up with new remedies, but also examples of new remedies such as suspensions, or what I call a declaration plus. That is a declaration with retention of jurisdiction, which normally only occurs with injunctive relief, which has to be very specific because it can be enforced through contempt of court.
Okay, well, thank you very much. Thank you.
So you finished. We'll just go to the video conference, and I'm not sure if Mark has any questions.
Yeah, thank you, Chair, and thank you, Professor, for the presentation. It's very informative and interesting. Going last, a lot of the stuff will have been asked that I was going to ask. I was particularly interested in the issue around the socio-economic rights and I suppose the failure or neglect, as you saw it, maybe to include that in the Canadian Charter. And while the Bill of Rights is seen largely as a focus on the rights of an individual, would you see the inclusion of socio-economic rights as a means of tackling wider issues such as regional economic imbalance and things like that? Because I know Northern Ireland's a lot smaller than Canada is, but you have within the north here, you have different areas with a huge disparity in terms of economic performance.
Yes. Yeah. No. I mean, I do, and I'm not even sure if it's just socio and economic rights. I think you can use equality rights in order to deal with pre-existing disadvantages. So if you have an economically disadvantaged community, I think you want to define equality rights in a way to ensure that they get equal treatment from government, whether it's be in policing or cultural, recreational activities. And you might even want to put in a kind of affirmative action mandate. So Section 15.2 of the Canadian Charter talks about how programs that are designed to ameliorate the conditions of disadvantaged individuals and groups are consistent with equality rights. So this was something that I think we wisely put into the Charter because we realized that simply a kind of Diceian sense of equality before the law can have a retrogressive effect, right? That we're all equal in that we can't sleep under a bridge, to paraphrase one author. So I would think about it in terms of equality rights, but also socioeconomic rights. But when it comes to socio and economic rights, I agree that they can be something that can help deal with class inequities, which are growing everywhere in the world. And I know there's a history of them in Northern Ireland, and there's concerns about, the historical legacy of employment discrimination and the like. And I think that should be taken seriously. But to go back to my pet topic of remedies, I think one of the things that South African courts have done really well is provide interim emergency remedies against things like evictions. So the South African courts are not going to be able really, and I think no court is going to be able to build better housing. But what they can do, and this goes to their ability to look at the plight of the individuals who appear before them, is they can say, you're not going to evict this person until you come up with some reasonable alternative. And it's those remedies in South Africa that have actually had the most bite. Even, and again, this is consistent with what I'm saying about dialogue, because what the court is saying is this person is going to be put out on the street. They have nowhere else to go. Government, you have to do something about this. But then also government, you need to consult with the affected communities about what the best way forward is to go. Because I think one of the lessons increasingly is that even disadvantaged communities have a lot of practical wisdom and expertise. They live their disadvantage every day. And I think you need to, ensure that future governments are forced to sit down with disadvantaged groups and individuals and think about practical solutions. But I think what a Bill of Rights can add is a kind of, what I think of as a legal emergency room, right? So when we have a healthcare crisis, we walk into A&E. I think you need to make courts more accessible, and you need to think about interim remedies that are available before a full trial. So if someone is about to be evicted, or if someone is about to have benefits cut off in a way that they can no longer afford medicines for their children, that they can get interim relief. Now, it may not be that you want courts and tribunals telling you exactly what medicines someone on social assistance should receive, but they can respond to individual cases of injustice, try to fix them, and then construct a process that would force the government to reconsider and justify the choices that it makes in the allocation of scarce resources. I think, in hopefully in a post-COVID world, we're all going to be dealing with less resources, but that doesn't mean that government shouldn't have to justify how they spend the diminishing revenues that they're going to have to deal with.
No, that's very interesting. Again, definitely glad to hear a lot of that. In terms of the historic issues you are aware of from our wee part of the world in terms of employment discrimination and what have you, fortunately we have laws in place now to prevent that, and I think on the whole they do a fairly good job of doing so. But these things are historic. They do run deep, and some of them still run today, not in terms of employment discrimination, but it's almost like there's a systemic or an inherent geographical discrimination within the not necessarily at the political level, just within the mechanics of the civil service, and how decisions are made, how funding is awarded to certain areas, and obviously there's a huge knock-on impact on the population of those areas. We do have plenty of lived experience here, all right?
No, and I don't doubt that, and you're obviously the expert on it. But when I look at the Canadian model, the fact that we provided for affirmative action for disadvantaged groups, including with respect to mobility rights, and my example about Newfoundland, which is an example of a province that, at least before it had a little bit of oil, really had suffered disproportionate hardships in Canada. These things were actually included in the charter, so that they didn't want someone from an advantaged group going and saying, I'm being treated unequally because the government is giving preference for a historically disadvantaged group. And the fact that that was included in the charter, I think, really pointed towards an idea that we would have substantive equality based on outcomes and results, as opposed to formal equality based on treating every person the same, regardless of their history and their family's history and their community's history. So we actually built in that idea of substantive equality, I would say, at the start from the charter. It was largely women's groups who did it, who were very disenchanted with the formal equality analysis that had produced, stupid decisions like, we're discriminating against you because you're pregnant, not because you're a woman. So again, for us, it was when we opened the charter, not the negotiation of the charter, not to experts like me, but to civil society groups. And so we had something called the Joint Committee. And this happened in late 1980 and early 1981, where a committee very much like yours sat in a big railway station in Ottawa and listened almost to any civil society group that came up. And a lot of those civil society groups made concrete proposals about what would be added to a draft of the charter that made the charter very much stronger. So again, based on the Canadian experience, I would say once you've come up with a draft, take it on the road. take it to those communities and allow individuals and civil society to have their say. And, there are parts of the Charter that I look at and I say, well, that's because the Canadian Civil Liberties Group Association, which had only 5,000 people, that provision is there because they went to the Joint Committee and they convinced them to add it, even though the governments did not think that the original drafters, didn't think that that was a good idea. So the Charter was very much enriched by civil society participation. And there's nothing like a draft to focus people's mind. So, I'm not criticizing you at all, and I'm happy you're talking to so-called experts. Once you come up with a draft, I would take it on the road and I would make sure that it's in every newspaper, that it's online, and listen to ordinary citizens, listen to youth. When you talk about environmental issues, it's our children and who have the most at stake. So I think one of the ways you can make a Bill of Rights, which is partly about universal things that all humans are concerned with, you can make it reflect the particular place you live, is to take a draft, do your best with the draft, but be open to suggestions for improvements.
Yeah, it's obviously vital that people have their say, but in some areas people are tired of saying what they have to say, and it's just means to say no, this really matters. This can change. It's just that so many decisions today seem to be based on or as a consequence of historical and unjust decisions made maybe 50 or 60 years ago. Like, I know at that time it's other members here will be sick of hearing us from Derry talking about it, but the decision was taken not to establish the base of Ulster University here in my home city of Derry, but instead put it to Belfast, where you already have Queen's University, and since then millions and hundreds of millions has been pumped into Belfast, whereas the campus in Derry has just been hollowed out, basically, and because that's where everything is, it's where everything goes.
Yeah.
But yeah. Thank you.
No, and again, like, something like Section 15(2) of the Charter that talks about ameliorating the conditions of not only disadvantaged individuals or groups, but regions within the community, would at least protect you. It might not ensure that the government, you might want to be more ambitious and have a commitment in the Bill of Rights to ameliorating the conditions of disadvantaged parts of society. But at least think about something like 15(2) and 6(4), which provides a carve-out for this important attempts to remedy historical inequities.
Okay, that'll be easy to remember. 15(2) is my weight and 6(4) is my height, so very good. Thank you.
Thank you. Congratulations on being so tall.
I've grown through my hair. That's the problem.
I haven't. Okay.
Cheers.
Cheers.
Thanks, Mark. I'm not sure. Does John have any questions? Is John still on? He's still there? Oh. No. Can you hear me now? No, you have no questions?
Yes, I'm okay, thanks. I'm okay, Chair, thank you.
That's grand. Professor, thank you very much for your time. You can take your ease now.
Okay, thank you very much.
Thank you.
It's been a pleasure.
Thank you.
Bye-bye.
So, members, the next item then on our agenda is number 3, a briefing on comparative international and devolved best practice by Dr. Katie Boyle, who's an Associate Professor in International Human Rights Law at the University of Stirling. So the clerk's memo, together with Katie's submission, can be found between pages 22 and 57 of your pack, and I'd like to welcome Dr. Boyle to the meeting. Hi, can you hear us?
Can you hear me okay?
I can just hear you now. Thank you very much for joining us this afternoon. So I'm going to start off, and thank you very much for your submission. It was very detailed and easy to digest. Some of the legal jargon sometimes can be a struggle. I just, if you don't mind, wanted to put you over some of the points, and you had laid it out quite explicitly, to be fair, in terms of the North and whether or not we are at a gap compared to the UK in terms of rights. And you had laid out the difference between the North and Scotland and Wales in particular. I wonder if you could talk about that, and then maybe our potential to fix that through a Bill of Rights.
Certainly, yeah, I think so. You're referring to the section of my paper which tries to better understand where Northern Ireland sits in relation to the rest of the UK. And what I wanted to highlight was that there is certainly an accountability gap in terms of economic and social rights in particular. And actually there have been movements in different parts of the UK in relation to that. And I highlighted some of the developments in relation to Scotland, which were that there's been a First Minister's Advisory Group, which I sat on. I know you've previously also spoken with my colleague Tobias Locke about this, but the First Minister's Advisory Group on Human Rights Leadership in Scotland made recommendations for a new Human Rights Act, a devolved Human Rights Act, which incorporates economic, social, cultural and environmental rights in devolved areas. So this is quite a significant development in terms of progressing on human rights provision in a sort of post-Brexit situation. And then also we have, for example, the Section 1 of the Equality Act, which has been devolved to Scotland and is now in force under the Fairer Scotland duty, which introduces a duty on public authorities to have due regard to socioeconomic disadvantage, and the same provision of the Equality Act has also been devolved to Wales. And in Scotland we also have the Social Security Act, which in relation to those areas which are devolved under social security, there is recognition that the right to social security is a right which is indispensable to the fulfilment of other rights. So a much more broader indivisible approach to civil, political, economic, social, cultural and environmental rights in that respect. So really quite significant strides. And of course in Wales there's already been developments in relation to the Children's Measure, which introduces a duty to have due regard to the UN Convention on the Rights of the Child. And now in Scotland there is a UNCRC incorporation bill where the Scottish Parliament is considering whether or not to incorporate the full treaty into Scots law in relation to devolved areas. And finally, Wales has also taken some steps in relation to trying to incorporate the right to adequate housing, as well as a measure which looks at well-being for future generations, which has quite powerful sort of requirements on public bodies to think about how their decisions can impact on the development of the economic, social, cultural and environmental rights of future generations. So these were just some of the examples that I drew on to demonstrate that the UK picture is actually much more complex than would first appear. There is really, of course, really important things to be aware of in relation to just how human rights under the ECHR applies, of course, because the Human Rights Act incorporates the ECHR in relation to reserved areas, but in devolved areas under Northern Ireland, Scotland and the Welsh devolved systems, you have a stronger form of incorporation of ECHR. And then it's also important, of course, to reflect on the way that equality law operates across the UK, which again is different. There's a GB system, across England, Wales and Scotland, and then a separate equality framework for Northern Ireland, and there's differences between them as well. So I think it just helps to paint a picture that the way that human rights operate across the UK has discrepancies and diverges in different places, and the devolved jurisdictions are on different types of trajectories to the national framework in relation to the protection of rights.
Thank you. And obviously, we don't have a single Equality Act in the North, and in laying out sort of the 2008 Human Rights Commission recommendations at that time, and I suppose you could look at that as being like ECHR almost plus. I'm wondering, what do you think are the added complications, particularly for socio-economic rights, in the face of leaving the EU and Brexit as we approach that?
Well, I think you have to bear in mind that I'm not an expert in European Union law, so first of all, what I say, a caveat with that fact, but EU law does go further than the ECHR in some areas, and there is of course the potential for the rights that are included in the EU Charter of Fundamental Rights to be developed further through future jurisprudence in relation to economic and social rights, and there are also under that charter some rights which go further than what are framework under the ECHR would facilitate, such as, for example, Article 47 and the right to an effective remedy. Apart from that, I think it's probably the potential of where EU law will go, which will be the greatest loss. So it's the loss of rights that may be developed under that system in the future, and it's really important for the devolved legislators to be alive to the fact that they have responsibilities in relation to devolved areas, which include many economic, social and cultural rights areas. So that's, there's a responsibility there to reflect on how far protections in those areas should go. And apart from that, it's also the types of remedies that are available under EU law that will be lost, and that's what the Supreme Court spoke about in relation to the loss of rights and remedies. That's essentially a really important aspect of the framework that we're losing under that area of law.
Katie, sorry, the clerk has just reminded me I ploughed ahead asking you questions without offering you the opportunity to give us your briefing. So I'm just so enthusiastic here. So if you want to go ahead with your briefing, and then we'll go to other members' questions. My apologies, folks.
Not at all. No. Very happy to just fire in. The way that I've actually framed my briefing is to ask questions and respond to them anyway. So. It'll be a question and answer format, because I thought it was probably the easiest way to set out the written briefing, and I appreciate that there will be questions, so I will keep the briefing as to 10 minutes and not go over that time to allow for questions. I've already covered some of the issues that you raised, but I just wanted to first of all highlight the fact that one of the first questions you'll often get about devolved legislators and what they're able to do is whether or not they have competence to progress on human rights protections, and that was one thing that I wanted to highlight. Does the Northern Ireland Assembly have the competence to introduce a devolved version of a Bill of Rights? And the answer to that question is yes, it does. It has the power to implement and observe international human rights obligations under Schedule 2, Paragraph 3C of the Northern Ireland Act, but it comes with some qualifications, of course, that it cannot legislate for a Bill of Rights in either reserved or accepted areas, and of course that means that the Bill of Rights would be restricted to transferred areas under the devolved system, and it also comes with the qualification that in the peace agreement it was envisaged that the Bill of Rights would be implemented through Westminster legislation, and so you have to think about the weighing up the difference between Northern Ireland Assembly legislation and Westminster legislation, and what each of them means. And it's really important also just to be aware of the fact that under the devolved framework, the Northern Ireland Assembly can't modify protected enactments, which includes the Northern Ireland Act and the Human Rights Act, and it can't encroach into what would be reserved provisions, which includes Section 75 of the Northern Ireland Act in relation to equality. The second question that I had posed within the written briefing was about whether or not the ECHR goes far enough. And basically, I mean, my area of expertise is in economic and social rights. And the most obvious gap in relation to, UK law-wide, but also in relation to each of the devolved jurisdictions, is that the ECHR does not sufficiently protect economic, social, cultural or environmental rights, that there is a great deal more scope to progress in this, and that ideally devolved legislators should take the steps to ensure that they bridge the gap in relation to what I would deem as an accountability gap, because essentially you're working within a framework where there is no requirement to justify decision making in relation to an economic and social rights framework, and that can cause an accountability gap, and it also reduces access to remedies for people who experience violations in relation to those areas. Should Northern Ireland implement a Bill of Rights? I very much wanted to highlight the importance of consensus and the process through which a Bill of Rights should be implemented, and it does require inclusive, informed, participative and deliberative frameworks, where I agree with what Professor Roach had to say in relation to it really being a bottom-up people's approach that has buy-in across society, and that takes a lot of capacity building. Now, I say that with knowledge that so much of that work has already been done in Northern Ireland, because all of the progress that happened in Scotland and Wales, for example, really was built on the work that had already been done in Northern Ireland in relation to the Bill of Rights. And so I think it's just important to highlight that whilst that's a question for the people of Northern Ireland, it certainly does come with its benefits in relation to having accountability for decisions in devolved areas, including adequate standard of living, housing, health, education, and dealing with issues around poverty and destitution and socioeconomic deprivation. Even yesterday, in relation to COVID, statistics came out which suggested that those who are in the least deprived areas, putting age aside, are twice as likely to die of COVID than those in those in the most deprived areas are twice as likely to die of COVID than those in the least deprived areas. And so basically what a Bill of Rights can do is try and introduce a decision-making framework which can help try and alleviate some of the social determinants of poverty and destitution, and looking at those broad areas of health and employment and social security and freedom from poverty and destitution. You've already asked me to comment on whether or not Northern Ireland is in step with the rest of the UK. And I've mentioned the developments in relation to Scotland and Wales, where there has been progress on incorporation of international human rights, and specifically in relation to economic, social, cultural and environmental rights. And those frameworks are being built around what are deemed to be best practice, which brings me on to just a short discussion on what kind of lessons can be learned. And you've already heard, of course, really important contributions around best practice from the experiences of different jurisdictions. So to just give you an idea of what the big story is in relation to this, when you look at comparative examples across different countries, what the international framework tells us to do, and the lessons that have been learned in other subnational or devolved areas. The ideal situation is that you try and introduce a framework where the legislature, the executive and the Judiciary are all responsible to act as guarantors of human rights, and so that framework would recognise that there is a role of the legislature in protecting civil, political, economic, social, cultural and environmental rights. There's a role also for the executive and administrative decision-making sphere. And then finally, there's a role of the court, and as already been mentioned, this is a model which encourages dialogue between these institutions rather than affording one institution's supremacy over another. And it's something which occurs across the globe. There are all different examples of how striking that right balance can be achieved, and what Northern Ireland has to reflect on, and what the committee might reflect on, is what would work for the particular circumstances of Northern Ireland in terms of getting that balance between institutions. So in relation to the first, I wanted to highlight the experience of the Finnish Constitution and the role of the Constitutional Committee, which looks at compliance with the Constitution pre-enactment, so it's basically what's called pre-legislative scrutiny. And the Finnish constitutional framework is really interesting because what it does is say that rights exist, including economic and social rights, housing, social security, employment rights, and so on. But it then places the obligation on the legislator to give substance and content to those rights. So there is a duty to introduce an act which protects a particular right. And so you have this nice balance between the legislator performing its role in relation to fulfilment of a right, as well as the committee within the Parliament scrutinising before laws are passed whether or not there's compliance with those rights through the committee framework. And it's something which you also have, for example, pre-legislative scrutiny in the Joint Committee of Human Rights at the UK Parliament. There's an Equality and Human Rights Committee in the Scottish Parliament, which has widened its remit to look more closely at pre-legislative scrutiny. There's also a committee, Equality Committee in the Welsh Parliament, which looks specifically at compliance with human rights. And I think there probably is more scope for a committee dedicated to pre-legislative scrutiny in the Northern Ireland Assembly, and there's different means through which you can reflect on how to embed human rights decision making within the Parliament itself, within the Assembly, to achieve more rights-oriented decisions from the beginning, and a Bill of Rights can help guide the legislator in that respect. The second kind of area of best practice is about how the executive itself, how the government can be a source or a guarantor of human rights. And so this is about the implementation and operationalisation of decisions which will help improve people's lives, and really a Bill of Rights is about guiding that process, about setting out the values and goals of a society and helping guide the executive in decision making. And it's the responsibility of both the Assembly and of the courts to hold the executive to account in that regard. And it's really helpful and encouraging to see that the New Decade New Approach deal basically encourages compliance with, for example, a wide variety of rights, including economic and social rights. So the political impetus is there to meet those standards, and essentially what a Bill of Rights does is to help provide a framework for that decision making, and also to make sure that no one's left behind in that respect. The final mechanism through which best practice in terms of learning from comparative examples internationally is the role of the court, and again you've heard quite a lot of that about that today. The role of the court is essentially an accountability mechanism of last resort rather than first resort, and it should be viewed in relation to how it can perform a role of holding the other branches of state to account by asking them to justify their actions. And there is often a lot of misconceptions around the court essentially overstepping its mark. So what I would say in relation to that is you can draw examples from other jurisdictions in terms of how the courts reach that balance. And what you'll see is that some remedies are follow what would be called a weak form of review, and others follow a much stronger form. And within the context of what constitutes an effective remedy, really the court has to have what I would call a constellation of options available to it, because each situation will merit a different response. Sometimes the court will really have to be much more deferential in its approach and, refer a matter back to the decision maker, whether that be the legislator or the executive, to say you need to revisit that decision because it doesn't comply with particular rights, or it may need to have a more interventionist approach. And in this area, I would draw your attention to the importance of structural remedies and effective remedies for what would be called systemic issues, which you will often find occur around the areas particularly of social rights. So in Germany, for example, the court has intervened where the executive has failed to provide social security mechanisms that would meet a sufficient threshold to ensure the dignity of the person, and it's relied on the Constitution to enforce that. Second, the South African court has used a reasonableness review to look at many different economic and social rights, including, for example, the right to adequate housing, and has referred matters back to the legislature and executive to say, you know, your approach to housing in this particular circumstances hasn't met the threshold of reasonableness, and you need to introduce a policy which more clearly achieves the aim of trying to ensure adequate housing for everyone. You also have the Colombian example, where you have what's called an individual writ, a tutela. And interestingly, in this scenario, what will happen is, if you see, or if the court recognises that many people are facing the same type of issue, which has become systemic, they can group the cases together and hear an action where they actually deal with a structural problem. So say, for example, there's a group of people who are all facing the same type of housing issue, and they might pull together all those cases and issue a structural remedy with orders to different components of government or public or private authorities that have responsibility for fulfilling rights. So that gives you a very broad overview of different examples of best practice. I would just say that when reflecting on where to go next, some of the things that are important to take into consideration is how to get that balance between the role of the Parliament, the Executive and the Judiciary. That the Northern Ireland Human Rights Commission recommendations do reflect best practice in terms of how they try to reach that balance, and so it is useful to use that work that's already been done in order to try and build on that to create a Bill of Rights that can serve the people of Northern Ireland. And of course, it's really important to also reflect on some of the issues, such as enhanced quality provisions and looking at the rights of different marginalised groups as part of that. And one of the areas which continues to be something which needs much closer attention is, if you're going to introduce a Bill of Rights, you also need to introduce mechanisms through which access to justice can occur. And that means also reflecting on what an effective remedy means in the context of Northern Ireland, and how you would enable access to effective remedies for violations of rights under any new framework. Thank you.
Thank you very much, Dr. Boyle, and apologies again for
Not at all.
coming on the topic. So I just have one last question. Obviously had asked others earlier, but just following on from the last conversation that we had and some of the questions that Mark had been asking around regional inequality and sort of the systemic discriminative practices that you end up with. Obviously, we can think of like the divide in the north, but there was also like a rural-urban divide, and we're still seeing the impacts of that. Mm-hmm. So in terms of socioeconomic rights, because we often think of that in terms of like housing and healthcare, but in terms of infrastructure, so you even look at like communication, your road network, rail, public transport provision, all of that. Is there room for that to be provided for in a Bill of Rights?
Yeah, so what you're talking about there, it's really about the allocation of resources to different communities and how to do, you know, there is only a limited amount of resources in any society, and decisions need to be made about how best to allocate them. So what the International Human Rights Framework provides for this is to basically try and build in a reasonable and sensible approach to decision making as early on as possible, so that fairness can permeate the system. So for example, when you're talking about geographical discrepancies between different groups, the international framework suggests that you have to allocate resources fairly. You have to allocate them the maximum available resources. So you start right back at the beginning about what budget is available, what areas do you need to prioritise, how do you ensure a levelling up of rights. You need data, therefore, to know, for example, which marginalised groups or geographical areas are more disadvantaged than others, and gathering that evidence is key to making reasonable decisions. So you start from a framework where you're basically trying to ensure allocation of resources in a fair way. You do so by making sure that that you're aware of who's disadvantaged and for whatever reason. So what you try to do is level up access to resources in a way that improves on a continuous basis, if possible, the access to resources in those different areas in relation to health, infrastructure, mechanisms to alleviate poverty and so on. And you do so in a way which applies vertically in terms of continuous improvement, but also horizontally, so that you bring everyone levelled up. So this idea of prioritising which areas need attention first and then levelling up so that everyone gets to access the benefits society can provide in that respect.
Thank you, Dr. Boyle. I'll now pass the Vice Chair, Mike.
Chair, thank you very much. Katie, thank you for your presentation. Just to follow on from the Chair's last question, I'm wondering how practical progressive realisation is in the Northern Ireland context, given it's fundamentally about the maximum available resources. How do you get agreement on what that represents in a five-party coalition government?
Certainly. So the progressive realisation is basically a duty which is formed or has a number of sub-duties attached to it. So it's essentially, as I mentioned before, it creates a framework for decision making, where you first of all are under a duty to take steps to try and achieve particular rights. You then need to try and introduce measures that respect rights. So that's basically to refrain from interfering with people's rights, to protect rights, which is basically to ensure that you introduce frameworks which ensure that others, including private bodies, comply with human rights, and that you take steps to fulfil rights, which is a duty to try and progressively achieve them. Connected to that is, of course, also a non-discrimination element. So this is about taking into account all the different groups that require to be considered. So, of course, in the Northern Ireland context, you have to ensure non-discrimination between the two communities that that were impacted in the conflict, but also all those other communities that are marginalised, which don't have a strong and powerful voice in political representation. So non-discrimination applies across the board to all different groups that would be recognised under, for example, race, disability, children, women, older persons. You have to think about the broader framework. Progressive realisation also requires allocation of the maximum available resources, which need to be deployed in an effective, efficient, adequate and equitable way, and that there is also a minimum core, and this is a really key aspect, and I think it's one in which often you'll find is helpful analogy to you ensure that there's consensus around rights, because a minimum core is about recognising there's a social minimum below which no one should fall, and it's often where we find that everyone is in agreement, for example, that no one should be living without adequate shelter, food and access to appropriate facilities, including water and sanitation and so on. And often when people live in poverty and destitution, they don't have access to that, and that can be forgotten about within communities. Or within societies that haven't introduced a Bill of Rights or some sort of framework which protects the most marginalised groups. You then have a duty to ensure non-regression, which means in times of economic hardship that you try and introduce measures which are proportionate, the least restrictive, temporary, and that they don't, you don't place the burden on the most vulnerable or marginalised. You try and share hardship between communities. And finally, that you have to have access to an effective remedy, which means ultimately a judicial remedy as a means of last resort, but you try and embed remedies much earlier in the system. So progressive realisation is a framework for decision making and applies to everybody, and really it's about responsibility of politicians in the Assembly as well as ministers in the Executive to try and take the steps to realise rights for everybody within society.
I just, again, on the practicalities of it, I fear that in the context of a five-party coalition government, that there's huge scope there for disagreement, up to and including one party taking a judicial review against another party, which actually is not unheard of in the history of the Northern Ireland executive, Katie?
Yeah, I think when you have I think when you're referring to, for example, a consociational framework, yes, you may face new challenges. And actually, I think probably what is required in that respect is political leadership to try and find ways to build consensus. A Bill of Rights can provide a framework. There's no flesh on the bones in a Bill of Rights. It's the responsibility of the legislature and the executive to introduce that. Put content and substance on rights. But ultimately, if the executive is not able to fulfil its duties in relation to taking the appropriate steps to try and achieve fulfilment with rights, you have to facilitate the opportunity for both the Assembly and also the courts to hold it to account. But I do think that there's mechanisms through which political leadership would enable consensus building around an agreed framework such as a Bill of Rights. There's no absolute provision and a requirement that a particular aim is always achieved. It's about trying to create a decision-making framework where decision makers can be held accountable and that they have to justify their approach.
That's helpful. Katie, thank you very much. Thank you, Chair.
No problem. Paula?
Thank you very much for your presentation. I just wanted to pick up on the suggestion there, or the option that you'd said about that they would set up an ad hoc committee on conformity with equality requirements for a pre-legislative scrutiny role. I'm just wondering, could that potentially significantly delay legislation coming forward, and would it not be better to actually train up or enhance the role of the existing statutory committee, whether it's health or economy? I just don't know why you would take that as a separate part of the process, or suggest that.
Yeah, it's an excellent question, because I wouldn't settle on any one form of enhanced pre-legislative scrutiny. I think it would really be for for this committee to reflect on it, but also for the Assembly to decide what works best within your particular framework. In Scotland, for example, some of the suggestions were about embedding consideration of compliance with rights across all committees, and that this would be enabled and supported through legal advisors around human rights compliance, which were termed within the context of the report they produced. The Equality and Human Rights Committee's report was to introduce this idea of human rights champions that work across committees to try and help embed better practice early on. Consideration of international human rights framework across the work of Parliament. And also you have, of course, pre-legislative scrutiny mechanisms in relation to the requirement of ministers to have their declarations on compatibility. You could have an enhanced form of that as well, and one which is published and transparent and can be scrutinised. So there's different mechanisms through which you can embed better practice within legislators, and I think it's about reflecting on the one that works best. So maybe perhaps, especially with less MLAs than MSPs, you might see that, for example, that's not the perfect way of achieving it within the Northern Ireland Assembly, but find a mechanism that works. You could have both. You could have an ad hoc committee which looks at very specific legislation where, for example, another committee is referred to the legislation to seek further guidance. And yes, of course, you're right, you need to reflect also on the practicalities of the time that would take. But I think pooling resources around constitutional experts and legal experts on human rights compliance would help with that, because ultimately it does often relate to constitutional and human rights legalities need to just be worked out.
Okay, thank you.
No problem. Michelle, do you have questions? We'll switch then to the members who are joining us via video conferencing. Mark, have you got questions?
Not really, Chair. I was just interested there in the discussion around the ad hoc committee. The provision for it does exist in our standing orders, and we've gone down that route once, just to my recollection. that one of the problems there, I think it's only the minister or the chair of the committee who are dealing with that specific bit of legislation that can make the proposal for the establishment of the ad hoc committee. One of the issues I found when it was established previously, or the one time it was used here around the welfare reform legislation, was it was largely members of the Social Development Committee who were dealing with the scrutiny of the legislation, who were then placed on the ad hoc committee as well, and it just became a bit of an echo chamber where you parties just bringing in the same arguments and largely having their minds made up before hearing from the experts that were brought in to the ad hoc committee. But I think it's a good tool, but if used right, it's a good fallback.
I think one of the lessons to be learned from the Finnish experience is that they really do rely on independent experts who specialise in constitutional law, and ultimately the decisions of that committee, which are produced predominantly by, it's a non-political committee, which tries to assess the constitutional compatibility, and once a decision is issued by that committee, the Parliament in Finland complies with that by convention. So almost acts as a form of scrutiny, a legal scrutiny earlier on. Now, as I say, it may not be that the practicality or the feasibility of that would work in Northern Ireland, but I think it is important to reflect on the idea that it's about applying non-politicised legal standards, and that there's a responsibility to hear experts who specialise in that as well. It's not just a political function, so to speak.
It's difficult to get anyone here viewed as independent. That's the problem. Thanks.
John, do you have any questions?
Yes, please. Katie, thank you very much for your presentation thus far. Very interesting. You quite rightly point out in your presentation on today that under the Good Friday Agreement, the British government had committed to enacting a Bill of Rights through Westminster, and they haven't done so, which sort of shows that breaking agreements isn't a new trend they've discovered in this last week or so. But my question is this. You have touched on devolved institutions passing a Bill of Rights or rights legislation as opposed to Westminster. What would be, where would be the best for us to have a comprehensive Bill of Rights passed in terms of the competencies of each institution?
Sorry, could you just, I'm not sure exactly what the question was. How do you achieve the best version, or sorry, could you just
which legislator, in terms of the legislator, we have an options in front of us. We could pass a Bill of Rights in the Assembly, or we could continue to press the British government to pass a Bill of Rights through Westminster. Which, in your opinion, would be the best pathway to take in terms of securing a comprehensive Bill of Rights?
Well, the most comprehensive Bill of Rights will be one which is passed at Westminster, because it can entrench in the same way that the Northern Ireland Act entrenches the ECHR. This is, however, something where there is what I would say it's contested whether or not the Northern Ireland Assembly could pass legislation which binds itself. You're going to see this sort of been tested out in Scotland with the UNCRC Incorporation Bill, which affords the court power to strike down incompatible legislation with the UNCRC retrospectively. So acts passed by the Scottish Parliament before the UNCRC bill was passed can be struck down. The difficulty is that you have a choice between a Northern Ireland Assembly Bill of Rights, which can't go as far because you can't encroach in reserved or accepted areas, and you are only therefore working within devolved competence. But you also can, for example, as I mentioned, technically bind yourself, so that future legislation could essentially repeal aspects of the Bill of Rights if it's a Bill of Rights at Northern Ireland Assembly level. Whereas if it was entrenched by Westminster legislation, it would take on a much stronger constitutional footing. But I think you have a difficulty insofar as how likely is it that you will get a majority in Westminster Parliament to pass such an act, and is there merit in reflecting on the fact that a Northern Ireland Assembly Act might get more buy-in and help with consensus building and capacity building across different communities. And you know, that's a difficult question to ask, but it's an important one to reflect upon. One of the suggestions I made in my paper was to reflect on the idea of having a sort of hybrid approach, where you do have a skeletal framework passed by Westminster legislation, but a requirement on the Northern Ireland Assembly to pass further subsequent legislation which helps give meaning and content to the rights which are in the bill. And that is not dissimilar to the Finnish approach, this idea of, you know, placing responsibilities back onto the legislature to provide for the rights. What was embedded in the peace agreement was Westminster legislation requirement. The courts could declare incompatible subsequent legislation by the Assembly null and void if it didn't comply with either the Legislature or a Northern Ireland Bill of Rights. And so that's the crux upon which there is a difference. It's about how entrenched it is constitutionally. I do think that a devolved Bill of Rights can go quite far when you look at what's reserved and accepted matters. I think
Our Wi-Fi is
probably
having here.
Sorry.
And so there is the
Sorry, we're having. I'm not sure if it's the same for your screens, but my screen is jumping all over the place. It's like watching a music video. It's flashing on and off. Not sure if it's the same. And the sound quality is pretty poor as well, Katie. But hopefully, Hallmark has picked up the points you have made, and I'll be able to review the record there. But I just want to. I think you covered this, but it was breaking up a bit. The devolved institutions are often asked to pass LCMs in terms of Westminster legislation. It's just, as you know, it's a courtesy they could overrule if they so wish. Is there a scenario where a devolved institution or Westminster can say to devolved institutions, for instance, the Bill of Rights, we are going to allow you to legislate beyond your usual or beyond the reserved matters on the specific issue? In relation to ECR, for instance, incorporating it into a bill, and then Westminster would have to ratify that bill at the end as well?
So, sorry, do you mean passing Northern Ireland Assembly legislation and then asking Westminster to mirror that? Is that?
Yeah, to ratify or to endorse the powers that the Assembly has included in their bill.
Yeah, of course. So, for example,
for one specific area, for instance, this term, the Bill of Rights, where I suspect the Westminster Parliament is not going to devolve permanently such rights to any devolved institution. So we would be temporarily involving ourselves in that realm of legislation, and then the Westminster would endorse that. Or maybe there's another constitutional way of doing it.
No, you're absolutely right. I mean, you already have competence to implement and observe in most economic and social rights areas. There's only social security contributions, pensions, and parts of equality law which remain reserved. But say, for example, Section 75, you could make a Section 4 order to request competence to modify Section 75. However, it's the scope of what you can do in a Northern Ireland Assembly bill is really goes quite far. for example, you're restricted insofar as you cannot modify protected enactments, but that's not to suggest that you can't supplement them. So that means you can go beyond ECHR, that means you can go beyond Section 75, you can progress in rights. So it's better to reflect on the protected enactments as almost acting as a floor that you cannot go below, but you can certainly progress. So there's already vast scope to do to work in and to broaden out progress in relation to other areas. And of course, you can request through a Section 4 order for some more issues to be devolved. And then you could, of course, make the recommendation that ultimately it would be preferred that a Bill of Rights was passed by a Westminster Act. However, you can't, there is scope for a Northern Ireland Assembly Act to go quite far.
Okay, thank you very much.
Thank you, John. And with that's the presentation finished. Thank you very much, Dr. Boyle, for your time this afternoon. And again, apologies for my intervention at the start of your presentation. So it didn't throw you off anyway. That was really useful. Thank you very much. So
it's all a pleasure, and thank you very much. And I commend all of you for undertaking the work. It's really important that it's happening, and thank you very much for the opportunity to speak to you about it.
Appreciate that.
Thank you.
Thank you.
Brilliant. Right, members, we can now go to the next item on our agenda. So we've got Chairperson's business, and there isn't any today. So then we can go on to the draft minutes. You'll find the minutes for our last meeting, which was held on the 2nd of July, at page 60. Are members content? Yeah.
Just one thing, Chair. John, I think, asked about outreach to youth, which we were going to tackle at the strategy day. Did we actually nail that down at Clifton House?
We didn't, I suppose, properly, but we do have in the correspondence a request to brief us from the Youth Assembly, is it they're
Youth
called?
Forum?
Yeah, Youth Forum, sorry.
Yeah.
Chair, I'd mentioned that we were exploring options with the education officers here at the Assembly to look at the possibility of doing virtual focus groups with schools. So the education officers are going out to their contacts in schools to see if that's something that we could run with. And as the Chair says, there's an item of correspondence there as well for consideration.
So they'll come back to us?
The education officer, yes, I will come back to members with our findings and if we can go forward with that.
Yeah, they're also on they're looking at the Youth Assembly and how you populate that. So that would seem to be don't overlap or duplicate.
Yes, Chair, I think the problem with the Assembly would be probably an excellent vehicle for this. Unfortunately, I think the time scale, it won't be until well into next year is my understanding, so it may be too late, but it's something that we can keep under review if members wish.
Yeah. Okay.
Okay, so happy to note the minutes for Nenstat, yep. Matters are raising. We don't have any matters are raising, so then we can go on to correspondence, agenda item number 7. And that letter from the Youth Forum is item 7.2. So they're asking to come in and present us. Are people content to have that? Yep. No dissent. So then we have a request for an oral briefing from the Equality Coalition. Again, are people happy that we agree to that? Mm-hmm. Yeah. So we can return to both those organisations saying that we would like to get a briefing from both of them. Are people happy to note the other items of correspondence? We've got a letter from the Executive Office, which is the last item, 7.10. If members are happy to note that. Yeah, everyone content? 100%. So then the next thing is item number 8, the Forward Work Programme. And we had obviously discussed this the last day. So if members are content to note that, obviously we had discussed the two visits that we would postpone them to later on as we see how things change. Everyone happy?
Yep.
Mm-hmm.
Yeah. So any other business? Nope. So our next meeting will be Thursday, the 24th of September at 2 p.m. in this room, when we'll hear from Amanda Cahill-Ripley and Roslyn Noonan and Sylvia Bale.
Thank you
so much.
This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29.